thank you all for coming. It's a packed room. We're happy to see that. We thought we were competing with lightning talks, and that sounds exhilarating. So thanks for coming to have what I hope is going to be a productive and hopefully a slightly controversial discussion on export controls of surveillance technology. So I'm going to briefly introduce the session now. My name is Lucy. I'm a policy associate at Access Now. I work on issues like cybersecurity, export controls, surveillance, data retention, all that fun stuff. If you don't know Access Now, check us out. You heard one of my colleagues earlier. And if you're staying for CPDP, you'll hear a lot more of us. So I'm going to introduce a little bit the framing kind of for this panel, then I'll introduce my panelists, and then I'll hand it over to them to make, let's say, 10-minute interventions. I'm going to be a little flexible if you want to do less or more, it's up to you. And then we'll open it up to you guys, and hopefully not just to ask questions, but also to bring in your perspective. So if you heavily disagree or agree, shout it at us. We want to hear it, so that's productive. So in September 2016, and kind of the inspiration for this panel, the European Commission proposed an overhaul of the EU export controls. Now, for those unfamiliar, export controls are a tool, basically a trade tool that we can use to kind of restrict the flow of certain technologies. Basically, the idea here is that there will be a human rights kind of weighing mechanism of what can be exported to other countries. This is really important because even though there have been human rights kind of qualifiers in export controls legislation in the past, this is kind of the first time that it's shifted from a human security dimension where it was weighed against very obvious military and defense threats to a more nuanced human rights framework. So now the weighing mechanism is more about the human right to privacy and the freedom of expression. So that's a nuanced shift perhaps, but it's really important in terms of what that's going to mean for certain categories of technology. This was, so in the EU we have this new legislation. Some of us who work on it have an issue with some of the definitions that have been laid out or have not. And the question is, how do we make sure those definitions at the same time allow us to have a very useful tool, but at the same time not restrict proper research and the transfer of technology as we would have it, in order to facilitate innovation and kind of information exchange around the globe. So it's a really tricky balance. Europe is kind of spearheading this, so the question is also, are we doing the right thing? And how is this actually going to translate for the end users? So some of the things that I want the panelists to discuss is, their experience with export controls and also other basically human rights frameworks in trying to control the spread of surveillance technology. Some of the things this is going to mean for the end users, or if it's going to be meaningless. Is this political posturing for the EU more than a results-oriented tool? So with that, we'll try to map out the situation, basically see what tools are out there, what works, what doesn't, and what we can push forward here in the EU to have an effective mechanism. With that, I will introduce my panelists. I have Ellen Desmet here from University Ghent and the Human Rights
Integration Network.
Perfect, thank you, HR Network. Then we have Joshua Franco from Amnesty International, Walter van Holst from say it.
Vrijschrift.
Vrijschrift. Thank you. And Renata Villa from the World Wide Web Foundation joining us. So a nice, I think, diverse amount of opinions. And Renata, if I can throw it to you to kick us off.
Yes, thank you for having me here. Just first thought on this. I think that the process of the discussion of this regulation in Europe was the most successful part of it. The exposing the many decision makers to the problem, and letting them learn what is all about these technologies, how those technologies can be used in harmful ways, and the proliferation of these technologies everywhere, and how those technologies were produced in Europe, it was a very, very positive process that involved many stakeholders and diverse opinions. However, I think that it is one of these feel-good but not so effective at all policies in Europe, because if I consider the situation of my country and the situation of other countries in Central America, I mean, politics matter, and when the European Union decides to choose which country is a human rights violator and which country is an ally helping us to combat terrorism, to combat the war on drugs, and to combat this or that, whichever noun that they use as enemy, then we are in trouble. And it's a very concrete thing. And if I look back into history and the embargoes and the restrictions imposed in export of military equipment to Guatemala, El Salvador, Honduras, and so on, I mean, armies and governments are resourceful, and so they can easily circumvent these kind of restrictions. And at the end of the day, what will for example, if Guatemala is considered a country violating human rights by the European Union, which is not, and it is, basically what Guatemala will do is to knock at the door of China, get it cheaper, get it even more pervasive than that, and even it will be like even more obscure. I mean, it's not creating an incentive not to buy it, or, I mean, at some point can expose the intention of a country not to buy from European providers, and Europe can feel good that, okay, a European company at least is not providing it. But I mean, even European companies can create, like the corporations and the way that corporations function today are no longer like grounded to a EU jurisdiction anymore. I mean, and in the case of, you can create a sister company in China, have a completely secret, sharing everything, and provide exactly the same software. That's one of the problems. In Guatemala, to go back to the story of my country, basically when the no European country and US couldn't sell us weapons, we got the weapons from the Israeli. And basically the connection was even made by the governments trying to restrict the technologies. That's one point. The other is also, I mean, the problem that we have to tackle here is the reduction of this proliferation of industries. And by artificially restricting just the supply to certain countries, we are just doing a look good, feel good policy, I think. And again, we have this duplicity in the discourse, so it is completely alright that a European Union country, UK, just passed the most abusive and horrendous law and can spy not only on their citizens but on everyone. But the European Union decides that this country cannot do the same that they are doing anyway. And it also places, I mean, it consolidates surveillance power somehow, and it gives the monopoly of the decision on who is authorized to exercise the surveillance and who isn't on a foreign country. And then we have again a clash on double discourse on free trade, but restrictions on some trade, but some human rights violations, but not, but you can still produce these products and sell it to us, but it is a mess. I think that is sending very mixed messages, is somehow even somehow colonialist at some point, and it is arbitrary. I think that a clear example, Central American countries just signed a free association agreement with the European Union. The human rights clause was completely removed out of it, but then they want to create these artificial patches that are very far away from a comprehensive human rights policy. So in my opinion, it doesn't make much of a difference. It removes actually, if I'm a lawyer, as a lawyer, if I want to sue a hacking team, for me it's convenient that an Italian company is selling this terrible thing to my government and not a Chinese company. I don't know how to sue, I don't know the laws in China, I don't know the mechanisms to hold them accountable. I mean, the more diluted that are these providers, the more remove the ability from me to take action in the relevant venues. And from my perspective, it is more convenient to just tackle the problem as a whole and not just put this patch that will have unintended negative consequences.
Great, thank you. That's quite the statement at the beginning. So the kind of message, and I'm not going to intervene just yet, but the kind of message is, is it kind of meaningless if we're removing human rights clauses, elsewhere, so that we have this patchwork, but at the same time, the European system works in a way that it does provide some kind of redress and traceability, right?
Well, just three points for me is cosmetic.
Mm-hmm.
It has, it might have effects that we haven't even considered. It is not tackling the issue of proliferation of surveillance technologies. It's not improving, it's not actually, it is susceptible to arbitrary labeling of a country as human rights violator, and that you cannot use this technology while others can by European views that are not immune from politics. And that's not ideal for this space. But it is good in the sense that it educated politicians to understand more about this.
Right, okay, cool. Thank you for your contribution, and then we'll move to, I think, Joshua, if you don't mind.
Sure. My computer's working very hard to save my notes, so I can't see them. So I want to talk a bit about human rights and surveillance. That was sort of my intro, basically what are we talking about when we talk about human rights and surveillance a bit. Coming after Renata's points, it may sound a bit out of place, let's see. So I don't want to sort of address that, nor could I necessarily address all of what she said with this talk, but I also don't want to come across as I'm just hammering the harm as if we're all unaware of that. Won't somebody think of the children kind of argument? That's not my point, but I do think it's important.
Hammer a little bit.
I do think it's important to spend some time with what that harm looks like and what we're really talking about here. So before I talk about why I do, and why Amnesty does support the EU proposal, well, we support the process anyway, I think it's useful to make at least one distinction at the outset, which is when we talk about the regulations or the proposal that was put forward in September, it's often, I find people tend to talk past each other a little bit about whether we're talking about what we could call actually existing export regulations or the regulations we aspire to have. So there are many valid criticisms that can be made and that we've in fact made of the existing regulations, but we aspire to make those a bit stronger. So I'll just put that out there as my one caveat for now and maybe return to that at the end. So really briefly, what we're trying to do over the last year or two at Amnesty is look at what surveillance means in human rights terms. And what I've looked at a couple of countries, I did some work in Belarus, and I have some work forthcoming in Uzbekistan that provide some examples of sort of what surveillance does to activism, what it does to free speech, and what we're up against. And when we talk about this stuff, it's not the GCHQ and the NSA tools and all of that are the coolest toys out there, but a lot of governments can get by with these sort of off-the-shelf solutions. One guy in Belarus that I spoke to made the point, and Belarus is a big country, but it's about 10 million people only, and he said, look, if you want to keep every dissident, every opposing voice in Belarus under surveillance, you only need to look at about 100 people. And he was exaggerating slightly, but the point is you don't necessarily need an NSA, GCHQ type solution to have a really repressive surveillance system. And what Belarus has, and as a caveat, not all of these things are tools that would necessarily come under the regulation or come from Europe or any of that, but it's just an example. Both mass and targeted surveillance that happens in Belarus happens through a system called SORM, which is common to a lot of post-Soviet countries, and what that does is it allows the authorities to tap directly into the communications networks of your phones and your internets without any supervision. They have direct remote control access 24 hours a day. They don't really need to show anyone a warrant, and the legal grounds for doing this are so broad that basically anyone could be subject to surveillance at any time. And it's also a pretty repressive legal environment to be an activist in. If you hold an unauthorized protest, if you receive foreign funding for an unregistered NGO, there's a lot of things that we would consider legitimate exercise of your human rights that can land you in jail there. So to be an activist is pretty fraught, and you have to worry about this. And there's a general assumption across the board that public spaces, and private spaces, your offices, your homes, your cars, streets, cafes, these are not safe spaces to have conversations. And I had people tell me that again and again. There was an incident when I was there of three opposition politicians in a cafe who opened up their napkin holder and found it had some really primitive bugging device into it. And it's just sort of everywhere, this constant threat of surveillance. And that makes it nearly impossible to operate. If you want to organize a meeting, you basically have to leave your phone at home, obviously, go meet someone in person, and arrange to have a further meeting in person if you want to do anything like hold a protest or something like this. So it just becomes cumbersome and difficult to the point of being nearly impossible, and it's really keeping people out of the public discourse in a way that shouldn't happen. And then, of course, you can also be targeted, so that's the general sort of chilling effect environment. But what happens when this data is used against you? So one example, I met a young activist that I called Ivan because he didn't want to use his real name. He's a student activist at the university. He had an experience where he was called into the administrator's office after he'd organized some protests and things, and the administrators were there with some people. He didn't know who they were, but he assumed they're KGB because that's the assumption that most people operate on. And they said, look, we've got your private messages from your VK account, which is Russian social media account. We know you're gay, so we're going to out you unless you start informing on your fellow activists, and we're going to kick you out of the university. And then who knows what happens? Maybe you'll be recruited into the army, yada, yada, yada. And Ivan, to his infinite credit, told him where to stick it. But he had a lot of problems because of that. He did get kicked out of university, and he suffered tremendously for his courage in that situation. Another case was a guy named Leonid Sudalenka. If there's any Belarusians in the room, please feel free to correct my pronunciation. But Leonid Sudalenka is an activist from Homel, and he's been an activist for decades. He's very well known and respected. He had a situation where his personal email account was compromised twice. He called tech support, got it back open, yada, yada, yada. Didn't think much about it. A few months later, he's out traveling and he gets a call from his wife saying, come home, come home. The cops are here and they're ransacking the apartment. They're looking for drugs and pornography. And he didn't know what that was. He was out of the country, but he came home. He was worried about his teenage son, and maybe they were suspecting him of being involved in drugs or something. And he got there, and it turns out someone had sent pornography from his email account directly to the prosecutor's office, and I think the tax authorities, which is a criminal offense in Belarus. You can go to jail for that. So it would have been monumentally stupid for him to do that if he did, which he didn't. And he, in the end, ended up being protected in some sense by his reputation, in the sense that a lot of national and international human rights groups came to his defense and made a lot of noise, and it became, he believes that is what prevented him ending up in jail over that. So if you're operating in these contexts, surveillance is a very real threat day to day. Have I talked too long? I've got other examples. Uzbekistan, same situation. There we know from Privacy International, they're using American and Israeli monitoring centers there, as well as, we all know about everyone's favorite hacking tool, Hacking Team. And what that does, I spent some time talking to Uzbekistani refugees in Europe about how that impacts on their rights in Europe, even though the surveillance is going on inside of Uzbekistan. And it came up almost incidentally in speaking to someone about this issue, that she hadn't called her family in Uzbekistan in 17 years, hadn't spoken to them because of this fear of surveillance, that people are afraid the cops will come knocking on your door the next day. And targeting also happens. There's a journalist based in Berlin who runs an independent news website, and she had secret sources inside the country because it's illegal to work for a foreign news organization without the permission of the Ministry of, I believe, Foreign Affairs. And you can be prosecuted for that. And if you're working secretly and you're not reporting your income, you can be prosecuted for tax evasion. So people have to keep their identities secret. And those identities were exposed when her email was hacked in Berlin. And those names of her sources ended up on a government-affiliated website in Uzbekistan, and those people were threatened with prosecution and had to flee with their families and leave their country behind. So this is what's at stake when we talk about surveillance, and it's everywhere. And taking Renato's point, it's definitely happening in Europe too. We're not blind to that. We know that Amnesty has been targeted by GCHQ in the UK. We know they've intercepted our communications. We had a ruling from the IPT, which is this sort of pseudo court that looks over surveillance practices in the UK, wherein we brought a case with a bunch of other globally organizations globally challenging international data sharing. And there was a ruling. They won't tell you if they spied on you, but they will tell you whether they spied on you and broke their own rules. So we got a ruling against, I think, the 7 of the plaintiffs saying no violation. We might have intercepted you, but if we did, it was within the rules. And one organization, the Egyptian Initiative for Personal Rights, we did break our own rules there. We kept the data longer than we should have. Go home. A few days later, Friday evening, we get an email. Sorry guys, there was one typo in that judgment. When we said Egyptian Initiative for Personal Rights, we actually meant Amnesty International, but the rest of the judgment stands, so off you go, have a nice weekend. So we know that happened, and we're working against that. I mean, we are involved in litigation against mass surveillance and other unlawful surveillance practices in Europe at the same time. But it's also, it's global. We were targeted by a really bizarre campaign from a fake NGO this summer. One of our workers on Qatar and migrants' rights there got an email from a woman named Amelie who represented a group called Voiceless Victims. Never heard of them, but they work on migrant rights in the Gulf. Sounds legit. They got a Facebook page with 5,000 followers and a history going back years. They've run major campaigns. They seem legit. But he clicked on something they sent, and it sent him to a really suspicious website that our networks caught, because we're a big organization and we have those resources. And so we had to think, has this organization been compromised? That seems the most likely scenario, because why else would they send us that? Or is it a fake organization? And we started poking around, and it turned out, through a very non-digital investigation, to be the latter. We poked around, and I just want to read this one because it's funny. Started looking at some of the things they posted. This is a post that Amelie put on their Facebook page for Voiceless Victims saying, as a human rights activist, I've always wanted to visit Africa. Unfortunately, human rights abuses are occurring on a daily basis in that area, and child abuse is one of the most common violations. And so this is some of the tip-offs we were starting to get. This is my friend characterized it in our write-up as saying, the absurdly non-specific reference to visiting Africa, the stereotype reference to the experience of African children, and the ultimately pointless nature of this posting made us suspicious, which it did. And so we started writing to them. We got some journalists involved, and they wrote us once back. They didn't answer a lot of questions, and eventually we actually sent someone to knock on their door in Lille, and nobody heard of them. The postman never heard of them. Their neighbors never heard of them. And as soon as reporters started poking around, their website went blank, and they put up a notice saying, Voiceless Victims is under attack, the bad guys have won. So I guess we're the bad guys. What's my point? My point is, this is a huge threat to activists everywhere. So when we talk about human rights and surveillance, I just want to keep us grounded in sort of what we're trying to, what's the evil we're trying to prevent here. Briefly on why I support this, and I'll leave that mostly to the other two panelists and the questions. That's a debate we can have here. Like I said, there's the existing regs and there's the regs we can hope to achieve. And I think although we're completely clear that this is not going to end the evil that I just described a minute ago in all corners of the world, it is a welcome first step, I think, and it is something that we need to push to strengthen. And where I really want it strengthened in particular is around transparency. We had a discussion earlier about transparency in another panel, but this is a place where I think it really could help. The UK and Finland do put some of their export license data online. It's not as much as I'd like to see, but there's some up there. And if that were out there for us to scrutinize, if people had to be a bit more public about the risk assessments they're doing and what they're selling to people, then that gives us a lot more information about the powers of those governments, and it gives people in those countries a resource to look at what tools their own governments might be using against them. So I'll pretty much end there, and well, just one more point on the legal framework, which is to say, and I think Ellen's going to speak more about this, is that the human rights obligation on states and on corporates not to allow their exports to be used for these types of human rights violations is an existing human rights violation. These regulations don't create a new obligation on anyone. They do create certain bureaucratic necessities, but this is a way to implement the human rights due diligence obligation that is binding on companies as part of their international obligation to respect human rights. And this is something that corporates, actors in other sectors have already had to deal with. If you talk to people in the extractives industry or elsewhere, you'll see that they encompass, that they already know about the duty and what it encompasses to some degree, some of them. And it involves, you need to conduct a risk assessment. What are the human rights risks of selling your product? How are you going to mitigate those risks? How are you going to monitor and know what they are? And how are you going to remediate, what kind of remediation are you going to offer if things go wrong? And that is a pre-existing duty that if you were to, for example, find yourself as a corporate actor involved in litigation where someone was claiming your product led to a human rights violation, your business led to a human rights violation, and you have to sit there and say, well, we never did a risk assessment, that's not going to be a good day in court for you. So these regs, go a little bit of the way towards facilitating people engaging in the process that they're legally bound to undertake, and hopefully will be a first step towards remedying some of these problems.
Great. Okay. Thank you so much for the contribution. I think talking about the kind of real experience with surveillance is important. That grounding. So thank you for that. And I guess Walter, if you want to take it away, speak a bit about the Wassenaar and EU regulation and what we're seeing in terms of the regulatory framework then.
That would be probably yes. May I get a show of hands? Who knows the name Wassenaar? And who knows the name? Those who raise their hands, who of you are familiar with the Wassenaar arrangement? Because Wassenaar is just a suburb of The Hague, so you could just by coincidence. Oh, by the way, the secretariat of the Wassenaar arrangement is in Vienna, just in case you might consider it any sensible. The Wassenaar arrangement is an instrument which has a lower status than a treaty, and it came into being in the early 90s, and it covers so-called strategic dual-use goods. And the primary incentive to get there was basically the Soviet Union and its satellite states had collapsed. There was still a lot of technology around there on nuclear, biological, and chemical warfare. That might be ripe for poaching by other state and non-state actors. And the idea was there was a kind of consensus internationally, at least in the industrialized world, that it would be a good thing to control, not to end up with a bunch of, let's say, ex-Soviet nuclear scientists working for Saddam Hussein. Or that was typical kind of scenario people were thinking about. In the same period we had the nerve gas attacks in Japan, so everyone was kind of on edge on let's say, interesting weapons technologies which typically tend to have a civil side, civil use as well. So that's where the term dual use comes from. Well, under the Wassenaar arrangement you have long lists of regulated technologies that varies from cryptography, which from a human rights perspective we rather not have as a controlled technology, lots of nuclear technology, biotechnology, all sorts of, well, basically, last time I browsed through the list I felt, no, I think almost any hackerspace would really love to have this stuff lying around. So it gives Renata's point about the extent to which you can control the technology. There are goods on those lists that I expect to show up in hackerspaces within 10 years because they come that easily achievable with digital fabrication and so on, but that's aside. Basically, this framework more or less functions. But the European Union is not in itself a signatory to Wassenaar. And by the way, Wassenaar is mostly non-binding. However, the EU members decided that it would be useful to implement Wassenaar in a fairly uniform way. And that's how the regulation on export controls on dual goods came into being, which basically gave the European Commission the authority to transpose mutations in the lists of Wassenaar into EU binding law through a regulation. And at some point we also got into the cases like Hacking Team, Gamma International, especially during the so-called Arab Spring. It was found out that to a large extent the surveillance infrastructures of the autocrats in the Middle East were basically supplied by Western, mostly European companies, which raises the question, do we find it acceptable or not? And it was quite widely felt that this was not an acceptable situation. So the Wassenaar arrangement got a new category of goods introduced, so-called cyber surveillance. And whether it is by bad luck or by bad intent, we ended up with a definition of, for example, exploits that are extremely harmful to information security research. And that has to do with the fact that under this arrangement, in this framework, any information technology is basically just treated as, let's say, uranium enrichment and centrifuges, as it is some fancy high-tech good that you cannot easily reproduce, and which is typically produced in very large top-down hierarchies, whereas information security research is done on a mostly individual basis in very loosely coupled, very international networks. In nuclear technology, you have this notion of intangible technology transfers, which got people prosecuted for having Chinese students in a class of nuclear physics in the past in the United States. That is literally an intangible technology transfer, giving a lecture on nuclear physics with students of the wrong nationality in your class. Well, if you apply that to information security, where everyone is continuously sharing information over the internet, this is problematic. So that is one human rights perspective. From a freedom of expression perspective, the Wassenaar arrangement is very problematic, which gets us back to the current proposal for the European Union regulation, which does not address that, but at least introduced additional safeguards that may or may not be useful. And the debate we are right now having within civil society is, do we actually accept this process? Do we actually accept this approach? What kind of safeguards do we find we're fighting for? How can we take out the pain of Wassenaar, or is it pointless altogether, as Renata more or less suggested? And I will just end this intervention with just give my opinion that I don't really care whether this kind of services are available from, let's say, China, Belarus, or Russia. I think if you're a company that benefits from the openness of a democratic society with the rule of law, or whatever remains of it in the current situation, but by and large it's still enjoying a situation that gave you the people with the knowledge, the access to the technology. You should not benefit from that situation and at the same time suppress any attempt at more openness in societies elsewhere. And if that forces the Guatemalan government to talk to the Chinese, so be it. That is my personal opinion on this. I think you should give the baton to Ella.
I think only mildly controversial there with your last statement about a democratic society and its responsibilities. But yeah, that's a really interesting question, and that's a really interesting point that Renata brought up as well, is how there is some kind of possibility of redress and traceability, from a European company, whereas once they start talking to China, everything kind of disappears. And it was highlighted also by you guys, we don't have a good enough insight right now into kind of export controls and all the things that pass from Europe. So, if we're leading on this, that's troublesome for the global situation. So Renata is up next, and I'm hoping you can discuss a bit of the. Sorry, Ellen. I'm sorry.
You can go twice.
I fear I have over caffeinated today, so I apologize. That's not for me being sleepy. That's me having too much caffeine in my blood. Perfect. Ellen, please take it away and hopefully talk a little bit about the human rights framework and the end user experience, and again going back to this kind of idea of redress and what does it mean for the humans on the ground.
Okay, thank you for the invitation. I'm coming in here from a general human rights background, so I want to start with a disclaimer that I'm not familiar with surveillance technologies and so on, but I was asked to present some perspectives that we developed in a research project on human rights integration from a user's perspective. So these are 2 points I first want to tackle on what does a user's perspective on human rights imply and what does an integrated approach to human rights mean. And then lastly, I want to talk a little bit of, okay, if we have companies that are violating the human rights of people in other countries by exporting such technologies, what can we do now within the human rights legal framework, and what are the possibilities and especially the limits today of this human rights framework. And can I start by maybe asking who of you, if there are many lawyers here, because it kind of changes a bit okay, so.
Hence higher a little bit, because I can kind of see them from my
One
angle.
third, okay,
It's a
so
mid change.
don't be ashamed, I'm a lawyer as well. It happens. So, so first of all, I mean, the term users has already fallen here, but more in the sense of users of technologies. I think it also makes sense to talk about using human rights. Who is using human rights? Who is invoking human rights? And how do they engage with human rights? And in this sense, if you think from that perspective, because mostly we study human rights, so okay, we're going to look at the right to privacy, or what does the European Court of Human Rights says about that article, or how does that convention work. But if you look at it from a user's perspective, if we take a kind of empathic approach of a certain person, institution, and so on, the perspective changes. Then you are confronted with all kinds of human rights norms, because they're not like, you cannot say from, okay, give me the catalog of human rights. There are many different instruments in which human rights are inscribed, binding, non-binding at the European level, inter-American, African, United Nations. There are general human rights instruments, there are specific human rights instruments, or certain topics of torture on specific categories of people. So if you look at it from a user's perspective, you immediately have this kind of, you're confronted with this complexity of the multi-layeredness of human rights, that there's not one human right, but you have different interpretations also given by different actors. And it makes sense to try to, use all these different interpretations and be aware of them, and not only focus on one. And also you can make a distinction between different types of users. The most important users, you could say, or the supposed beneficiaries of human rights, would be the direct users, the rights claimants, those who invoke that their human rights are being violated. Then another type of direct user would be the rights realizers, those who are realizing human rights. In principle, the states are the primary duty bearers of human rights law, but you could also have individuals, organizations, and so on, which actually really want to realize human rights in a specific situation. On the other side of the scheme, you have what you can call indirect users of human rights, who in a way link up with the direct users. And for example, Amnesty would be a supportive user who is supporting other people to invoke or to have their rights realized. Also lawyers, human rights defenders, international human rights institutions would be supporting the realization of human rights of others mostly. And then a final category after the rights claimants, the rights realizers, the supportive users would be the judicial users, those who can impose a certain human rights obligation to a state. If the European Court of Human Rights says from, okay, you Belgium has violated the right of this or that person. So that's very briefly this user's perspective, which may make sense as if, okay, we're not going to talk about the right to privacy in general, but what does it mean for journalists in Azerbaijan, and what are the different human rights that are at stake? Not only right to privacy and freedom of expression, but maybe also freedom of religion, maybe also right to non-discrimination, because maybe he's put under surveillance because of his membership of a particular ethnic or cultural community, or because he is disabled or not, and so on, so that you take all these human rights into account. And that you also look, because now if we look at the mechanisms that are in place to enforce human rights or to look if human rights are complied with, they're often also focused on a specific team. The European Court of Human Rights is mostly focusing on civil and political rights. They have brought in economic, social and cultural rights. The Committee on the Rights of the Child will primarily deal with children's rights. But it would make sense if all these actors and also people on the ground and organizations working on human rights would take an integrated approach and not focus too much on one right, but try to see for one person, how do these different rights come into account, also from a perspective of intersectionality, where different identities or different aspects of your identity intersect, and that can actually lead to a greater violation of your human rights than only one aspect. So that was a bit apart on the user's perspective and integrated approach. I don't know, try to make sense of it for you within your specific working context, if it makes sense at all. The last point is that if we look at this issue of exporting surveillance technologies, what can we do from a human rights law perspective? And then we are confronted with a very basic weakness of the human rights law system, that states are the primary duty bearers. They are the ones that subscribe to their human rights obligations. They're the ones that are being primarily accountable. And in a way, corporations, for now, are not the primary duty bearers. But we have seen an evolution within mostly soft law, human rights soft law, I would say, towards trying to conceptualize, trying to make these human rights obligations for corporations more concrete. Are you familiar with the Ruggie framework? Does it make sense to go? Yeah, so maybe first to say that there was first another norms on transnational corporations where there was actually a proposition to say that corporations should have the same range of obligations as to human rights as states, but that proposal was not accepted by states and corporations because they thought it would go too far. And then in the framework proposed by Ruggie, the special representative that was appointed to discuss this issue of human rights obligations of transnational corporations, there was actually made a distinction between the duty of the state to protect and the responsibility of the company to respect. So in that sense, this wording of difference makes it clear that they didn't want to go as far for the companies as for the state, that there's a responsibility, but the real legal obligation is within that framework still a bit lagging behind. Possibly the good news is that there has been an intergovernmental working group established to work on a treaty that would be a legally binding instrument on the obligations of human rights and transnational corporations. So that could be a useful tool also within this context, if it happens, because there have only been 2 meetings up to now with very constructive discussions and so on, but nothing really coming out of it in a concrete way. So that could be an interesting tool. Also, you have other kinds of non-binding human rights instruments like the OECD guidelines, where you have national contact points, and they have actually also already taken some action in the context of the export of surveillance technologies, where, for example, there was a consortium of NGOs led by Privacy International who filed a complaint with the National Contact Point of the UK against a company that was exporting technologies to Bahrain, and then there was a process of mediation which failed. There were recommendations. So there are non-binding procedures to try to sensitize at least these corporations to their human rights obligations. They remain non-legally binding, but they can have effect as to naming and shaming, as to financial investors maybe wanting to retract from investing in that company, government that will decide to leave them behind. So you can have some consequences, even though from a strictly legal perspective it remains a non-binding procedure. So these were some of the points I was thinking about in this
Brilliant.
context.
And I don't think detached at all. In fact, I think that's a really important, framework for us to think about. And this is, in a way, this is exactly what you mentioned as a very streamlined kind of part of human rights. When you speak about the courts that focus on certain things, here we are just talking about technology. So, question is, do we lose out on a bit of a more holistic approach? And are we addressing just a tool rather than addressing this kind of crisis of democracy that might be happening in that country? And that's a definite issue. So thank you for that. Thank you very much. I think it was a very useful overview. So I will open it up to the floor. I think at this point, if anyone has questions, or brilliant hands already shooting up, or opinions, as I said, you can either direct a question or just state kind of your take if you've been dealing with this or you have experience on the ground. We're willing to hear it. So please, and if I can just ask if you can say your name and maybe affiliation if you're comfortable with that. That's.
Hi, Georg. I don't have a specific affiliation. I used to work with a group named Telecomics a few years ago that we helped Syrians circumvent surveillance and censorship that was performed by the Assad regime. I'll try to organize a bit my thoughts because I have mixed thoughts and feelings about all this. I cannot disagree that we should try to restrict. That is not a good thing that a company sells